And who are they lobbied on behalf of?
My Lords, I rise to strike a jarring note, though I don't intend to wander into the potentially treacherous waters of the divisibility or otherwise of the Crown. But I think the government has rather got it right on these amendments, and noble lords are barking up the wrong tree. As I've said both in committee and at second reading, noble lords, in some cases, appear to have misconceived this bill throughout, as if it were an enforcement measure against criminal or quasi-criminal activity. But it is not, and it never has been intended as such, nor does it have that effect. So we come to an amendment that says explicitly no preferential treatment may be conferred on members of the House of the other place or members of your Lordship's House. But of course, to the extent that is already a criminal act and corruption is involved, criminal proceedings would be the right thing to undertake, and not proceedings under this bill, which is essentially administrative in character and which carries no punitive clauses. Because the remedy for breaches under this bill, in most cases, is for a supplier to sue for damages, to sue for the fact that they've been treated badly or unfairly. This is not a bill intended to combat corruption. And of course, if you're going to exclude explicitly members, and it's required, noble lords feel it's required to explicitly exclude members of this House of another place, but it's not required then explicitly to exclude giving preferential treatment to your first cousins or your family in a broader sense, or your best friends, or people you were at school with, or all sorts of other persons who perhaps should be listed on the face of the bill, if specifically mention is to be made of members of Parliament and of this House. If I could then briefly come to the question of the Procurement Review Unit.
I wonder if I might intervene. I apologise for not being able to rise, and I thank the noble lord for giving way. Does he not agree that Clause 40 allows the government to set up such a preferential channel?
It has, I think, been agreed by all members of the House that in certain circumstances the government needs to be able, in emergency circumstances, to take action outside the normal procurement channels. And if Clause 40 has the effect of doing that, that is fine. But Clause 40 would also, as I say, allow channels to be set up which would include, and how would you know it, people you'd been at school with, people who were your best friends, or people who had been your best man, or attended your wedding, or whatever. These things can't be set out comprehensively on the face of the bill. This is a classic case of shutting a stable door after the horse has bolted. With the Procurement Review Unit, there again seems to be a notion that it needs to be on a statutory basis because it's going to have some enforcement capacity. Now, there might be, I personally doubt the need for a Procurement Review Unit at all. But if the government chooses, amongst the many multifarious activities it does, to ask a number of civil servants to monitor the way in which this bill, if it becomes an act, is being implemented, then that's a perfectly legitimate thing for the government to do. But it is a decision by the government to ask its own civil servants to do something which appears to be relevant and important to them at the time, and the circumstances may change. The noble Lord Aberdare mentioned, for example, the fact that it could monitor late payment, and that would be a perfectly worthy thing to do, because late payment of invoices is currently an important matter. It might not be an important matter in the future. It would be very strange to have this set in statute in this way. This is just a civil servant, a group of a civil servant department. It doesn't require this statutory basis because it isn't going to have the enforcement powers that noble lords seem to suggest. And similarly in Amendment 113, the desire to spell out an ever longer list of persons who are covered by the conflicts of interest matters, of course, has the same tendency, as I mentioned in relation to Amendment 72, to exclude and, so to speak, exonerate those who are not specified in the list. The list is a potentially endless list by the time you've thought of everybody you might want to include in it. I've spent over 30 years, and I don't boast about it because there are many noble lords who've spent as long or longer in public life in one capacity or another. And throughout all of that, I've understood that conflicts of interest will arise in the course of one's activities, and the key question is how one manages them, to manage them in a way that requires sensitivity, flexibility and responsibility in each particular case. And if I'd entered public life and conducted myself dishonestly, and I assure noble lords I have endeavoured not to do so, but if I had intended to do so, I would have managed to achieve a degree of dishonest advantage, I can assure you, whether this has been spelt out in this essentially procedural bill or not. If I had done so in a way that was clearly a breach of the criminal law, I would, I hope, have been prosecuted under the criminal law under a wide range of offences that are available to prosecutors for corruption in public life. But it would not be this bill that I'd be looking to, and it's not this bill that would be used in my case. So I think I have made this point on several occasions. I think noble lords are misconceiving the purpose and nature of this bill as essentially a large enforcement framework. I'll make one final point before I sit down, and that is a sense of proportionality is required as well, because one has to remember that the bill is intended to apply not only to multi-billion contracts let by central government departments, but also to modest contracts let by local authorities and other smaller public bodies that are caught within its net. And I think at every stage one has to bear that degree of proportionality in mind. So I very much hope these amendments are not pressed to a division, and that my noble friend will stand firm and not allow the bill to be distorted, further distorted, I might say, in this way.